in a lot of ways for a lot of people. If you have a box on your screen that says this meeting's being recorded, just click got it. And if you're not comfortable being recorded or being seen, feel free to turn your camera off. Otherwise, we'll ask that you can leave it on so that our presenter is looking at people and not all a bunch of black boxes. So yes, this came because we often get phone calls from people who are struggling with different issues around tenants' rights, leases, legal questions. And so this is being brought to you in partnership with Éducaloi. And we're really very lucky to have a lawyer here who's a specialist in this area who can address some of the different issues for you. I encourage you to collect your questions throughout the discussion, and you can send them to me in the chat box, which is at the bottom center of your screen. If you scroll down, you're going to see in the middle of the bar at the bottom chat. You can click on that and a little chat box will pop up. Enter your question, I'll see it, and we'll have a discussion with Rick after his presentation on the various issues that you guys raised that you feel are a priority or you would like to have covered again. So I've told you we're muting, we're filming. At the end of this webinar, we're going to send you a link for a MailChimp survey to ask you about your experience. How was the webinar? Do you feel that you learned, you know, enough, that there was proper information, that you walked away knowing more than you arrived? It will really take just a couple of minutes of your time, and I appreciate a lot you sending any feedback you have. That would be great. So as I said, today we're focusing on tenants issues and housing for seniors. We do have someone in the room, I don't know how to say this, not in the room, but in the room, I guess. Someone named Alex who's working in the West Island and asked if I could just say a couple of words. She is working on a tenants' right committee in the West Island, and they're looking for seniors who've had different experiences with renting and leasing. Alex, can you put your information in the chat box for everyone to see? That would be great. It'll be easier for them. There we go. Thank you. You'll see it. It's locataire@tqsoi.org. If you have anything you want to contribute to that project, it's a 3-year project. I think it's really interesting, and I'd like to see more of these projects happening around the province. So, you know, please feel free to contact Alex and let her know about your experiences. Okay, enough from me. I think I've covered everything. Please stay on mute. Unless you have questions, please send them in the chat. You've got an agenda. We're going to stick to it as much as we can, but you know, please understand things do sometimes go back and forth a bit. I'm now going to present our speaker. Again, I feel very lucky, and thank you to Éducaloi for providing this expertise to us. We're going to be joined by Rick Goldman today. He's a lawyer and plain language specialist with Éducaloi. I'm just wondering if I should say a bit about Éducaloi or if Rick will. They are an excellent org. Oh, you will. Okay, so Rick will. He's the expert. I'll let him cover it. He provides support to the Anglophone community groups across Quebec, offering legal information to the public. He's been a lawyer for more than 30 years. He has a wealth of experience in the community sector and was a staff lawyer at Project Genesis, a Montreal community group advocating for housing welfare and other social rights. He's also served as coordinator and committee to the Aid Refugees. In addition to working at Éducaloi, Rick also serves as supervising lawyer at the Just Solutions Legal Clinic in the Montreal City Mission. So Rick, thank you so much for joining us today. I really appreciate your time, and I'm going to turn it over to you.
Okay, thank you so much, Vanessa. So I guess we're going to do a share screen of the presentation. So I'll wait for that to come up, because you are very nicely handling the technical side today. I don't have to worry about that. Okay, so we'll go to full screen. Terrific. So that's the topic, as Vanessa told you: landlords and tenants, rights and responsibilities. Maybe we could just advance to the next one. Yeah, sometimes it's a little tricky whether you click or We're out of the
I
share
have,
screen.
I can't do it full screen. It's not doing it right now. I'll try one more time, but if not, I'll just do it in the regular view, Rick.
Okay, okay. Okay, that's good. That's fine if you can advance it that way.
Rick, if I could ask you to just speak a little louder, please?
Oh, really? Usually I speak too loud. Okay. I don't know if I should hold the mic. Does that help? Is that better?
No, you were good just there before, so I don't hold the mic. That's going to be
Don't hold the
cumbersome
mic.
for
Just
you.
speak a little louder like this?
Yeah, perfect, because some
Okay.
seniors have a little issue.
Well, I'm a senior myself, actually, by most definitions. Okay, so yes, let's go back to or let's go forward to the next slide. So just jump in if I'm not speaking loud enough. All right, so as Vanessa said, I'm going to say a few words about Éducaloi. We are a nonprofit organization, so anything we provide, whether it's a workshop, whether it's a document, whether it's a pamphlet that we send you, when we're going to talk about our different resources, it's free of charge. Okay, our main resource, you're looking at our main resource, it's our website. And on that website, it could take quite a while just to go through the website, so I'm going to just say it quite quickly. We have about 1,000 pieces of content in English and in French. Just about everything is mirror image. If you find it in one language, you'll find it in the other. On the left-hand side, you'll see the different parts in the news and so on. So I'll just mention quickly what each of those are. In the news, that's the sort of latest developments. If there's a new Supreme Court case that just ruled, like for example, the one about Mike Ward, the comedian, and his freedom of speech to, in my opinion, denigrate disabled people, but the Supreme Court didn't see it that way. That will be in the news. Or a new law that has come out. For example, there'll be an overhaul of certain laws about curatorship in the next little while. So you'll see articles about that there. The next one is the law by topic. So for example, our topic today is landlord tenant. And if we were to go through this and click through the law by topic, we won't do that. You would see that one of them is landlord tenant, and it covers in great detail the topics that we're covering today. Then we have web guides, which are where we group together. It's not different content, but it's grouped in a handy way. For example, there's a web guide for seniors. There's a web guide for people who newly arrived in Quebec. Then there's publications. These are the documents that you can actually order from us. And once again, free of charge. So there's, for example, a lengthy detailed guide on wills, one on power of attorney, and so on. You can go to publications, you can order them in print, in paper format, we'll send them to you. You can also, if you're handy and you have a printer, you can download them in PDF format, that's easy to print format, and print them up. But if you want to order a print copy, it'll be sent to you free of charge, even the postage. We're a nonprofit organization. Then the last part about is where you'll find the members of the team and more information about our mission and so on. Okay, so that's a very quick look at Éducaloi. We'll move along now. So here, remember I said there's a whole section on landlord tenant. You're going to see just 2 or 3 now of the articles that you would find if you went there, which you'll see are covering the topics that we are covering today. So we could just advance. There's 2 or 3 of these. So this is responsibility of landlords. We'll just advance. Responsibility of tenants. We'll advance again. Renewal of lease, something that we're going to talk about. And so just to give you an idea. So I think now let's advance again. And we're going to get into the workshop outline. So these are the topics that we're going to be covering today. The actual tribunal, formerly known as the rental board. And by the way, just to make things easy, I'm going to call it the rental board today when I talk about it, although the official name is the Tribunal Administratif du Logement, the Administrative Housing Tribunal. But because almost everybody still calls it rental board, we'll just stick with that. We're going to look at landlord responsibilities, tenant responsibilities, rent increases, moving out, renovations, and special issues regarding seniors residences. These were some of the topics. Well, in fact, I hope I'm covering all the topics that were suggested to me by Ruth as topics of interest. And so we'll look at those. And if there are other topics, I'll do my best to answer as well. So let's get right into it right away. So we can advance now. Okay, so the rental board itself, for those of you who are handy with internet, there's the website. And what will you find there? You'll find quite a wealth of information, and you'll find different forms. For example, we're going to talk about refusal of rent increase. You'll find a form for that there. For most rental matters, you don't have to use an official form. We'll come back to this, but for example, to refuse a rent increase, you can write a letter by hand, 2-3 lines. You don't have to use their official form, but you might find it handy to use their official form, and they have quite a few of them there. Now, some of the terms you'll see that the official term for landlord in the Quebec law, in the Quebec Civil Code, is lessor. The Quebec, the official term for tenant is lessee. The official term for cancellation of a lease, whether by the tenant or whether it's a landlord who's evicting a tenant, is resiliation. So we won't use these terms today because we're going to use like regular terms like landlord, tenant, and eviction or cancellation. But if you go to the website, you may of the rental board, you may see these terms. So just so that they are familiar to you. Okay. So what is the tribunal? It's a kind of court. It enforces the rules on apartment rentals, and you can contact them. If you go to the website, you'll see a phone number, but you can email them with different questions. And we'll see some situations in this presentation where either a landlord or a tenant might end up taking a case to the rental board and having a hearing. It's an informal, it's kind of an informal court where the idea is to keep the costs very low. Most people go without a lawyer. The cost of taking a case there, especially since you don't have to have a lawyer, is a small fraction of taking a case to a regular court. So that's the kind of idea behind the rental board. Okay, so we can advance now. Okay, so the first topic we said was the landlord's obligation. They must provide a clean and safe apartment. They must make sure that other tenants don't disturb you, and they must do necessary repairs. Sometimes it's hard to tell. There's some very minor repairs. We're going to come back to this that the tenant is responsible for, but general rule, if a repair is necessary, it's not some really minor thing like changing a light bulb, or purely cosmetic, like your paint is faded a little after a couple of years, but there's no problem. It's not peeling off over your stove or your bathtub. If it's a necessary repair, like a broken door, window, light fixture doesn't work, the landlord is going to be responsible for it. Okay, let's advance. Okay, so what happens if the landlord doesn't respect their obligations? So your light fixture in the kitchen isn't working. It's very hard for you to do anything in the kitchen. A window has developed a leak. Winter is coming. What if the landlord, what if you call the landlord? Well, hopefully, once you call them, they'll take care of it. But what if they don't? So you inform the landlord in writing, and you give them 10 days to fix the problem. This is if it's not super urgent. We're going to come to urgent, as you can see, a bit below. Now, if they don't resolve it within 10 days, they don't come and fix your window, fix your light fixture, as the case may be, you can file at the rental board for a variety of things. The main things you would ask for are a reduction of rent, damages, or even if you find it's just very difficult to live there, you could ask to have your lease canceled so you can move somewhere else if that's what you want, and ask for damages to cover your moving expenses and so on. You can also ask, I should have put this in, for an order that the landlord carry out the repair. So there are different things that you can ask for, and the rental board can provide more information about that, or we could talk more about that. Now, there's another category of repairs. These are urgent repairs. So this is, for example, a pipe has burst and your apartment is at risk of, or even being flooded. In that situation, you have to try to contact the landlord. So get on the phone right away, or if the landlord or the janitor is in your building, go bang on their door. And if you can't reach them, or if you do reach them and they just say, well, big deal, pipe burst, I have a lot of things on my mind, I'll get to it when I can. That's not acceptable. So in this situation, just of urgent repairs, you can carry out the repair and deduct the cost from your rent. This is the only situation in Quebec law where a tenant can deduct something from their rent without getting the permission of the rental board when there's an urgent repair. Okay, so let's move along. Okay, so what are your obligations? So you have to take care of your apartment. You have to use it in a reasonable and prudent manner. What does that mean? Not carry on an experimental, science experiment that burns the walls or breaks things. Not disturb other tenants. Not play tenor saxophone at 1 in the morning. Not play your TV or radio or whatever, stereo very loud in the middle of the night, and do small repairs. This is really very, very small repairs. So again, I mentioned before, when I'm talking about the landlord's repairs, the landlord has to do pretty much everything you would consider a necessary repair. When we're getting into tenants repairs, it's very minor things. So things like changing a light bulb, or for example, you put up a painting in one spot, you made a hole to do it, that's okay. Now you've taken that painting down to move it somewhere else, there's a small hole, you would be responsible for filling the hole and doing a little touch-up painting. You couldn't ask the landlord to do that. Okay, so let's move along. Okay, so still with the tenant's obligations, no big surprise here. You must pay the rent. Okay, that's the most fundamental obligation that the tenant has, pay the rent. Now you can face eviction if either, these are two different situations where you could face eviction related to rent. If you fall more than 3 weeks behind in your rent, and I have to tell you, as someone who has dealt with landlord-tenant problems over many years, a lot of tenants don't think it's just 3 weeks. A lot of tenants think it's longer than 3 weeks. They could fall 3 months even behind in the rent before they start to have problems. The law is actually very strict. It's only 3 weeks. After that, the landlord could take the case to the rental board to ask that the tenant be evicted. Even then, the tenant could pay the rent and any costs the landlord has had, which are small, to bring the case to the rental board, and the tiny amount of interest that would be owing if you're a couple of weeks late, and you can avoid eviction. So, but more than 3 weeks, you are at risk of eviction. Now, another one separate from that, though sometimes connected in a way, is that you are frequently late in paying your rent. So you're never 3 weeks, you're not necessarily ever 3 weeks late in paying your rent, but you're often a week or two, and this goes on, and the landlord could ask for eviction. They normally have to show that this is causing them a problem. Like, for example, a very typical situation is a landlord has their mortgage due on the 1st of the month, and because they're not getting their full rent on time, they're getting penalties and interest because they're paying their mortgage late. That would be a classic situation. But once again, even if you never fall 3 weeks behind, you could be at risk of eviction if you frequently pay your rent late. Okay, so let's move along. All right, so here's a little quiz for you. Is there any limit on the amount of rent increase a landlord can ask for each year? So I guess you could type in the chat. We can give you a second, say yes or no, and we'll then, you know, see what people think, and we'll continue. So once again, is there any limit on the amount of rent increase a landlord can ask for each year? If you think there's a limit, say yes. If you think there's no limit, say no. And those of you who are very knowledgeable and part of an organization, don't cheat and give the answer. Okay, so have we given enough time? Okay, so Vanessa or Katya, I'm not sure if you're keeping an eye, or Ruth, on the chat. I can't see the chat from this view.
There's a lot of yeses coming in.
A lot of yeses.
Yeses, yeah.
We'll give another 15 seconds or so. Okay, let's call it there. So roughly, what's the proportion? Or even just if it's hard to.
It's almost all yes. I think
Okay.
there are like a couple saying no, but most of them
Okay.
are yes.
Okay, let's advance. It was a bit of a trick question. The answer is no. And the trick is that the key word is ask. You can ask for the sky, okay? I can go out in front of my building now and ask the next person who comes by to give me $20. There's nothing illegal about that. What they answer me is another matter, but I'm allowed to ask. And a landlord can ask you for 100% rent increase, but that's different from what they can get, okay? So we're gonna explain that. So the answer is no, okay, to that question. Again, I apologize, a bit of a trick question to get you sort of, you know, involved and, you know, make it a bit more interactive. But the answer is no. The landlord can ask for anything. They can ask once each year, okay? So they can't do this 3-4 times a year. It's once a year. And even if your lease is shorter than a year, some people have 6-month leases or even 1-month leases, the landlord can only ask you once a year. Now, the vast majority of people in Quebec do have 12-month leases, so I'm not going through all the situations, but I'll go through the most typical, the 12-month lease. The landlord has to ask between 3 and 6 months before the end of the lease, before it's the date that it would come up for renewal. Let's look at the most typical situation. Somebody has a lease that starts on July 1st of each year and runs into June 30th of next year. This means that the landlord must ask for the rent increase by March 31st. That's why a lot of people get these in March, you know, towards the end of March. The question was put to me actually as preparing this. So a lot of people are not happy because they get their notice in the first week of January. First week of January, mainly we're concerned about if we can get, you know, down the stairs of our building and, you know, to the supermarket without breaking our neck. And we're not thinking about June 30th and lease renewal. But unfortunately, fortunately or unfortunately, depending on your perspective, this is legal. Remember, I said a moment ago, between 3 and 6 months before the end of the lease. So January 2nd, the first day probably, or 3rd, whatever, the first day of mail delivery, you could get your notice of rent increase. So once again, no maximum to what the landlord can ask. You have 1 month to respond. So this is where people are upset. You know, 5th of January, they get their notice. The landlord has asked for a certain increase. They're not sure if they want to renew. They're not sure if what they're going to be, what their situation is going to be 6 months from now at the end of June. It's very far, but that's how it is. Those are the rules. You have 1 month to respond. Now, if you refuse, if you don't do anything, your lease is automatically renewed with the amount that the landlord has asked for. So the landlord sends you You get on, whether it's January 5th or whether it's March 15th, you get a rent increase notice that says the landlord wants 5%. You don't do anything. Your lease is automatically renewed for 1 year. I'm using still the same example of the 1-year lease starting July 1st. Your lease is automatically renewed for another year, and you're hit with this 5% rent increase. But you have options. You could refuse. If you do refuse, if you say, I want to stay, I'm not going anywhere, but I refuse this increase, this 5%, I refuse it, the landlord then has 1 month to file at the rental board. And then the rental board will rule on the amount of the increase. I think somebody put it, just flashed by in the chat, something about the rent increase calculation tool. That's exactly on point. If you go to the rental board and click around, you'll see the tool, and you'll also see each year they issue a communique that gives the average rent increases for different types, different situations, whether the landlord is heating or the tenant is heating, if the landlord's heating, whether they're using oil or electricity. But overall, the rent increases are averaging, when the people go to the rental board, 1 to 2%. So you could see that that a lot of the times, I mean, typically landlords will ask for much more than that. And tenants who know their rights and refuse, and the case goes to the rental board, they end up with quite a small increase. Another option, of course, is to just negotiate with the landlord. And if the landlord actually knows what they're doing, they will often settle for less than the 5 or whatever percent. They'll settle for the 1 or 2%, and nobody has to go to the rental board. That's another option. But make sure that while you're negotiating and talking and so on, you don't let that 1 month deadline go by. Probably the safest thing is to send a refusal, make sure it's done within the month, and then negotiate. Then it's the landlord who has to keep the eye on the deadline, not you. Okay, so we'll advance. Of course, we can come back to all these questions in the question period. Okay, so moving out. So one of the basic, we touched on it before, but let's be even clearer about it. One of the basic protections in Quebec is automatic lease renewal. So if nothing happens, okay, you don't do anything. We gave the example before of if there's a rent increase notice, you could accept it, you could refuse it. You have different options. You can refuse it and then negotiate. You have different options. But what if nothing happens? What if the landlord doesn't send you anything and you don't do anything? Well, what happens is your lease is automatically renewed. You're paying $900 a month now. You don't do anything. The landlord doesn't do anything. It's going to be renewed for another year at $900 per month. Okay, so this is a very important protection of Quebec housing law, of Quebec rental housing law. It doesn't exist in any other type of lease. If you lease a commercial space for a store, you don't have these protections, including automatic renewal. If you lease a car or a tool, none of this exists, okay? It's only for Quebec rental housing. And if you come from another province or you live in another province, it might be quite different there too. Now, let's say you want to leave at the end of the lease. So there's different situations. If we go back to the previous one where you got a rent increase notice, that's actually the last point here, give notice within month of receiving rent increase notice. So let's look at a whole scenario, okay? It's March 15th of 2022. Your lease is coming up for renewal at the end of June. March 15th, you get a rent increase notice. Landlord says, I want 5%. You have decided, for whatever reason, that's it, you're done with this apartment, you want to move out. You must give the notice you must give the notice that you're moving out within 1 month of getting that rent increase notice. So you must give it before April 15th. You must send the landlord a notice saying, I'm moving out, I'm not renewing my lease. That's it. Okay, that's one scenario. Now here's another scenario. The landlord doesn't send you anything, okay? The landlord maybe feels they're happy with the rent, you're a good tenant, they're not gonna bother to try to get 1 or 2% more out of you this year, they send you nothing. But you wanna leave. In that case, you must send your notice 3 months before the end of the lease. That's the situation in the middle of this slide. So let's look at the scenario. You know you want to move. You're thinking, well, the landlord's going to send me a notice. I'll just tell him when he sends me the notice. But he doesn't send you a notice. So you must keep your eye on the ball. You must keep your eye on the deadline. And by March 31st, you must make sure that the landlord receives a notice that you will not be renewing your lease. Okay, so that's if you haven't received anything from the landlord. Okay, so we'll move on. Okay, now there are some, normally you can only leave at the end of your lease. That's the general rule. Just as the landlord, you have a lot of protections against the landlord. The landlord has certain protections too that you can't just pick up and leave whenever you feel like it. So there are, so general rule, you've got a lease that goes till June 30th. You can't end your lease before that. You're responsible till June 30th. There are some exceptions, okay? If the apartment is unfit for habitation, this is an exceptional situation. We're not talking about a couple of repairs, even if they're necessary repairs. We're talking about unfit for habitation. The classic example came about 20 years ago now, when we had the ice storm in Montreal, and many apartments immediately became unfit for habitation, and people were allowed to leave them and end their lease. Okay, and they couldn't be held responsible because the apartment was no longer fit for habitation. But there could be other examples, such as infestation, flood, and so on. Still, these are very extreme situations. Now, with 2 months' notice, there are a number of situations so that you don't have to wait until June 30th. So if you're moving to a senior's residence, you're living in a regular apartment, but you're going to be moving to a senior's residence. If you can't continue living due to a disability, if you've been on the waiting list, maybe a couple of years for government low-cost housing, HLM, and you're finally admitted, or you're a victim of domestic violence. In each of these cases, let's take an example. You find out now in November that February 1st, you'll be admitted to a senior's residence. So you don't want to be responsible for your lease for till June 30th. So you can send a notice now saying, I'm breaking my lease on February 1st because I'm moving to a senior's residence. You have to attach proof that you were admitted to this residence, and then you'll be able to end your lease on February 1st instead of waiting until June 30th. Okay, so we can come back to all, any questions about this, but let's move on. Okay, so now one question was raised, well, what about the landlord's right to show your apartment, once you've given the notice that you're leaving? Well, landlord has a lot of rights here. They can show the apartment to prospective tenants. They don't have to give you advance notice. Now, in most situations, for the landlord to come into your apartment, they do have to give advance notice. If the landlord wants to do a repair, or even the landlord has the right to inspect your apartment periodically to, just make sure that you're taking good care of it. I want to caution, this is periodically. I don't think they could do it more than once a year. They have to give you 24 hours notice. But in this exceptional situation, they don't. So let's look at a scenario, okay? You got your rent increase notice March 15th. April 5th, you sent back the notice saying, I'm not renewing my lease. So that's it, I'm leaving June 30th. From then on, the landlord can show your apartment between 9 a.m. and 9 p.m. It's quite a strong right the landlord has, but the landlord must be present. The landlord themselves must be there to accompany the prospective tenant. Otherwise, if somebody knocks on your door and says, the landlord sent me, I want to take a look at your apartment. Landlord's not there. You can say, I'm sorry, I don't let strangers into my apartment. And make an appointment, go see the landlord, come back with the landlord, make an appointment with them. But unfortunately, they don't have to give you that 24 hours notice. Okay, so that's how it works with that. So let's move on. Okay, now renovations. I was told about quite an abusive case that somebody went through, that Ruth told me about. This is a very, very complicated area. I'm going to go through the rules, but it's just that there's so many scenarios that it's difficult to summarize it in a very understandable way. Because, and the main problem is this, well, the main problem is there's, like I said, a lot of scenarios. There are renovations where the landlord asks for the tenant to leave, and the renovations where the landlord says, well, you know, I'm renovating, but you can stay in the apartment. You know, for 2 days, you won't be able to use the kitchen very much. And, you know, somebody be in the kitchen during the day, but you can use it at night. You know, you won't be able to use your bedroom on such and such a day because we're doing some plastering and painting, but it's only 24 hours. So there's situations where the landlord doesn't ask for you to leave. And there are also situations where the landlord does ask you to leave. And there are different rules for them. And on top of that, and this I think was the situation that was brought to my attention, there are situations where the landlord should ask you to leave because it's impossible to live there. The situation that was brought to my attention was somebody living on an upper floor with limited mobility who needed the elevator, and the elevator wasn't available for a long period. Yet the landlord claimed the person could stay there, so it's just a totally abusive situation. So I'm going to go through the rules, but again, there's so many scenarios that if you've got a question, we're going to have to look at a very specific, a very specific scenario that you mentioned, because there's just different rules in different situations. So if the landlord doesn't want you to leave, or only wants you to leave for a short time, less than a week, they only have to give 10 days notice. You know, that in itself is kind of problematic. If you have to leave for a week, say, or 6 days, 10 days notice isn't a lot. Now, if the landlord says, sends you something saying you don't have to leave, but you know, you consider this situation abusive. All right, so this actually reflects the situation that was brought to my attention. The landlord is saying, you don't have to leave, don't worry. We're going to do the renovations with you there. But in fact, the person who lives on an upper floor will not have access to an elevator. It's a completely crazy situation for the landlord to say you don't have to leave. The tenant in that situation can apply to the rental board to rule on the situation. And we're going to see the different things that the rental board can say. Now, unfortunately, we're going to have to talk about all the different situations kind of at the same time when we go through the rules. So let's say the landlord says you're going to have to leave for 3 months. This is not a rare situation. The landlord says, I'm doing major renovations, you're going to have to leave for 3 months. So then the landlord will have to give 3 months notice. That's a lot more reasonable. In fact, anything more than a week, the landlord has to give 3 months notice. And they have to offer you, if you're going to have to leave at all, they're going to have to offer you an indemnity. That is generally the cost of leaving with a mover and coming back. Of course, you leave for 6 days and go to a hotel, it's one thing. If you leave for 3 months and go to an apartment, it's another thing, and the landlord's going to have to pay much more. Now, in the situation where the landlord has asked that you leave, you have 10 days to answer, but you're well protected in that if you don't answer, then you're deemed to have refused, which means you don't have to do anything. And then it's up to the landlord to ask the rental board's permission. So, you know, I'm just sorry, I kind of apologize for how complicated this area is. But, you know, those are the different rules in different situations. Now let's just advance. It continues on the next slide. So if the case comes before the rental board, so in these different situations where a tenant feels that something is abusive here, for example, they're being told you can stay in your apartment, but it's crazy. The conditions don't make sense in terms of staying in their apartment because, for example, they won't have access to an elevator. So in that case, the tenant has to go to the rental board, has to file at the rental board because the landlord claims that the tenant can stay in the apartment. So the tenant files at the rental board, but then the whole burden is on the landlord to show that the work and the conditions, including how much they're offering you in terms of money to leave the apartment, are reasonable, or the rental board itself can set the conditions. So let's use this example of the person who was told, you can stay in your apartment, don't worry about it. You can stay in your apartment while I do the renovations. But in fact, there won't be any working elevator for 2 months. So this is completely crazy. So the person files at the rental board and says, I object to this. This is abusive. Everything is frozen. There's no renovations can go ahead until a hearing is held, and the landlord must show that the conditions are reasonable. In that, if the rental board is not satisfied that what the landlord is proposing is reasonable, they can refuse the permission. They can say, no, forget about it. What you're proposing is not reasonable. You can't do it. Okay. Now, another option is the rental board could set the conditions, could say, well, you can go ahead with these renovations, but you have to offer the person an indemnity to leave their apartment, to come back to their apartment, that is the moving cost, plus the rent for a place they'll have to stay during the 3 months that the renovations will take. So the rental board can order that the landlord respect certain conditions. But the worst thing is if the landlord claims, like I understood this situation, that the person doesn't have to leave, the person doesn't realize that they could contest this by going to the rental board, and then the landlord goes ahead with this crazy situation where the person is trapped in their apartment. Okay, so let's move on. Okay, that actually kind of completed a first big block, everything except for, well, now there's a big block about seniors residences. So I leave it up to Vanessa or.
Yeah,
Yes.
no, I'm here. So we do have a couple of questions. And actually one that came up twice. So I'll put it first. And that's, and I'm sure we all hear about this, Montreal is dealing with a major problem. If you're living in an apartment and it's infested, often one person's talking about bed bugs, the other person didn't specify. And then the landlord or owner brings in a fumigator and then says, all right, problem solved, but the problem isn't solved. Either the bugs just move to another unit or they're still there and the tenant keeps finding them. What can a tenant do in that situation?
Well, that's the, I don't know if we want to go back to that slide of if the landlord doesn't respect their obligations. The landlord is not, landlord is doing something. They're not just saying, I won't do anything. I think, yes, that's it. But they're not doing a proper job. They're not doing you could call it a type of repair. They're not doing it properly. So in that case, if the only option is that, for example, I mean, I'm not an expert on fumigation, but the only option is that the entire building be fumigated at the same time rather than just one apartment. The bugs move next door and they move back a month later, then the rental board can order that. So inform the landlord in writing that this is not working. You know, they might have been doing their best, but they didn't understand that this was an insufficient solution. And then you can file at the rental board for any of these things, reduction of rent, damages, if you feel you have a better option to move to, rather than pursuing this repair situation, cancellation of your lease, or an order from the rental board to handle the repair in a specific way that would be more effective than what's being done now.
While we're on the slide, another question to this, is there some kind of guideline as to what is considered an urgent repair?
It's case by case. So, and unfortunately, I mean, there's some that are indisputable. I mean, I gave the example of
A flood,
the burst
yeah.
pipe. Another thing would be heat during winter. If the heating system failed, let's say, I'm assuming the landlord is responsible. Let's assume in this situation the landlord is responsible. It would be okay for you to buy space heaters and charge the landlord for them, because otherwise you would freeze. So that's after trying to contact the landlord, and the landlord doesn't do anything. The landlord says, I'm calling the heating technician, and it may take 6 or 12 hours, then they're doing, you know, what they're supposed to. But there is no guideline as such. There's no list. So you have to use your best judgment. In a worst case scenario, you could, if you deduct the money from, let's say you do an urgent repair, the landlord said, this wasn't urgent, you just called me, I would have had my guy come and take care of this. How can you deduct $200 from your rent for this? The worst case scenario, if you want to avoid any risk of eviction, you can pay the landlord the $200, or $500 or whatever that you deducted from your rent, and then claim it at the rental board. Because in theory, if the landlord is right that it wasn't urgent and you shouldn't have deducted it, then the landlord could say, you didn't pay your rent for November.
Right.
It's a non-payment of rent. You're more than 3 weeks late. I'm going to get you evicted. So that would be one way to handle it. Use your best judgment, and we're going to see some reasons. First of all, we saw the rental board. There's some other resources like the tenants hotline, information clinics from McGill Legal Information Clinic that you could call and say, I mean, unless it's so clear that you don't think it's necessarily like your apartment's being flooded, if it's some kind of borderline case, you could call around, see what people think, and then make a decision. I could almost say, to formulate a rule, if you have time to call anyone but the landlord, it's probably not urgent.
Right.
You know,
Yeah.
But that's, you know, if you've got a particular situation, maybe we could talk about it, but I won't necessarily have an answer because every case is different depending on the facts.
Someone gave a good piece of advice to a friend of mine, and they said that if there's any kind of question ever, because this is sort of one of those shades of gray where you can end up fighting with your landlord, take a picture of everything. Everyone has a phone, everyone has a camera on their phone. Well, maybe not everyone, but many of you do. Take photos so that you have proof that this pipe leaked, or because if you end up in front of the rental board, you want to have some kind of evidence, some kind of, if it ends up a he said, she said situation, try to protect yourself.
Pictures and any documents. So the plumber comes, it's an emergency call, $400. You've got a receipt for $400 from a recognized plumber, you know, so,
Yeah.
Okay.
Yeah.
All right.
Here's a particular situation, but I'm sure you see versions of this. So this is somebody in the chat who has been living in their home since 2019, and the renovations haven't stopped. And there's a list of all the things that have been done. They were told by the rental board that they have 3 years to claim a reduction of rent and/or an indemnity. And now they're being told that they cannot claim back to 2019, that the indemnity will only start at the date of the mise en demeure.
Okay, for damages that you have suffered, you can go back 3 years. So I disagree with that. You know, you can't, okay, typically you require a formal warning, you know, before you take an action at the rental board. But if the damage has already occurred before you could have sent the warning, then you can go back 3 years. In our law, in the basic Quebec civil law, you can claim anything for anything that's happened in the last 3 years. So maybe the confusion is this: for a rent decrease, generally it'll be only from the time that you say, I'm suffering a loss of enjoyment. Let's say you're paying $1,000 a month and these renovations are ongoing and you want a rent decrease. Normally be only from the time that you send the notice saying, I'm suffering a loss of enjoyment of my property. I want a $200 decrease in my rent until the renovations are finished. But for everything you suffered in the last 3 years, you can claim damages, which is kind of similar to a rent decrease, but it's not calculated on a month-by-month basis. So in my opinion, somebody who has been enduring a loss of enjoyment, let's say for the last 2 years, and continues to suffer that loss of enjoyment, can claim two things: damages for everything they suffered for the last 2 years, and a rent decrease starting whenever the rental board rules on the case until the renovations are finished. That's my legal opinion. If the rental board tells you otherwise, I think they're going to have to explain why the normal rule of being able to claim for damages, anything that happened in the last 3 years, doesn't apply in this situation. To me, it applies.
Right. So again, in communicating with your landlord, somebody wants to know if they're sending a letter to their landlord. PS, I've got this from a few people. Send your mail registered. Just general people are recommending. If you're sending a letter to your landlord to refuse a rent increase, is it critical at that point that you clarify that you do want to stay and negotiate? Or is that like done
No,
later
not
on?
at all. You don't have, I would say I'm giving my opinion. Okay, I'll give a legal answer. It's not necessary. There's absolutely no necessity to say that you're open to negotiation. I would say it's probably better not to say it, just to say I refuse, and then in a separate communication say I'm open to negotiation. If you feel more comfortable on a human level, saying just you find it too harsh to refuse, you want to say show that you're a reasonable person, then just make sure that it's clear that there's one paragraph that says I refuse the rent increase, but I wish to renew my lease, point, period. Another paragraph, I am, however, open to negotiation. Just so there's no confusion, like I'm not, like the worst situation would be is, I'm not really happy with this rent increase, can we negotiate? Meanwhile, your deadline for refusing passes and nobody's too clear whether you refuse
On what's
or not.
happening, right?
Yeah.
This last question I think may be covered in your next section. If so, but you referred to a tool when it comes to assessing a rent increase. If your rent includes things like meals, a garage, a cleaning service, are there any kind of guidelines on how those increases are determined?
It's integrated into that table. So
Okay.
if you find that table on the rental board website, it says calculation tool. Maybe I know there's somebody from an organization here who I think even mentioned the tool. Maybe you could post it in the chat. Otherwise, if we keep the meeting open for a couple of minutes after the presentation, I think I could find it and post it. It has a certain amount, that tool has a certain amount for each type of thing. Like, for example, if it's electricity heating, oh, I see somebody, Nat has very
Thank you.
nicely posted it. It will say, for example, electricity, the amount of increase that factors in is 1.2%. Maintenance, a certain percent. And services, it will also say, I think it's something like 2%. So it's not unlimited. They can't say, well, because the company that we're hiring, at least this is my understanding, the company that we're hiring to provide meals is charging us 5% more, we're going to charge you 5% more. There's a built-in factor of something like whatever, 2%. So it's built into that.
Okay, great. The person who we were discussing their issue with the 3 years, I don't know if you know this off the top of your head, but they were wondering what the Code Civil, the article number would be referring to the 3 years.
Okay, that's the general, it's called prescription. So this is a legal term, it's misleading legal term because it sounds like something you go to the pharmacy for, but it's called prescription, and it means when your right extinguishes. So the general rule in Quebec is 3 years. There's very few things that expire in less than 3 years. Some other things are 10 years, but it's 3 years. I don't have it off the top of my head, but again, if we keep the chat open, I could find the article of the Civil Code that says something like, the general rule in personal actions when you're suing another person is 3 years.
3 years. Okay.
Okay.
I'm going to do the last 2 questions and then we're going to take a little break, everyone. So here's somebody, this is a similar sort of issue where they're in contesting with their landlord. A pipe has burst from between the apartment above and yours. The smell is very strong of the sewer. and the person couldn't sleep at all or eat anything as they weren't feeling well. After 3 days, the landlord came. Is there anything to be done about the not being able to use the kitchen sink or feeling unwell?
Absolutely. This is a situation, it's exactly the situation we're talking about, where someone could sue for damages. You wouldn't normally sue for, I'm hoping the situation was resolved and the issue was, well, first of all, that it happened, and second, that the landlord took 3 days. And so one could sue for 3 days of lost rent plus inconvenience. You know, you had to go elsewhere, you had to buy meals elsewhere. It took your time, it was stressful. You know, the rental board can give something for that. It's not like the States where you get $1 million if your coffee is too hot and you burn yourself, probably get a couple of hundred, but you do have the right to claim damages in that situation.
Great. And then lastly, someone has asked, what is the delay that a person who is complaining could expect to hear back from their landlord? I guess what's
Well,
like a reasonable time frame?
You normally give 10 days. That's like a kind of general rule in Quebec, except for urgent situations. You give 10 days. As to when an individual landlord will answer, that depends on the individual landlord. A responsible one, if it's something like we gave the examples of things that are maybe not urgent, although even some of those could be borderline, like a light fixture in your kitchen not working, or a window having developed a leak. Even those could be urgent. If you can't use if your apartment is dark and you can't use your kitchen without that light fixture, that could be considered an urgent repair. If it's -40 out and you have a little leak, which wouldn't be a big deal in the summer, that could be an urgent repair. But let's not complicate things. Let's assume it's a non-urgent repair. You send the 10-day notice. A responsible landlord should deal with it right away within a day or two. But in order for you to take the case to the rental board, normally you give them 10 days.
Okay, I'm going to ask this last one because I think it's really important and it's not always clear. What are the cases where your apartment insurance comes to play versus going to your landlord?
Okay, that is a bit outside Quebec rental law, exactly in the sense that you have a contract, a private insurance contract with your insurance company, which is not in any way governed by Quebec rental law. So normally, whether it's your fault or whether it's the landlord's fault, if you have a damage in your apartment, you can claim from your insurance company, okay? Now, there's a couple of factors that come into play. If it's your fault, probably you have no choice, okay? So you cause a fire in your kitchen. Actually, if you claim from the landlord's going to say, you caused it, so why are you bothering me? You better fix it, okay, at your cost. So you really have no choice but to claim from your insurance company. Even then, and it's getting into a whole other topic, first of all, there's a deductible that can be quite high, $1,000, $2,000, $3,000. So if it's $1,000 to fix your kitchen, you're not even going to get anything. But let's say you did a lot of damage and it exceeds your deductible, you may still want to think about it because your premiums will go up. So they'll do your repair, they'll pay $1,000 to do your repair, but maybe your premium will go up, I don't know what, $50, $75, and then you're stuck with that for a long time. So there's a lot of considerations there. That's if it's your fault. If it's the landlord's fault, then you have more of a strategic, more options. You could still claim from your insurance company, and if the insurance company thinks it's the landlord's fault, they will claim from the landlord to reimburse themselves. And if they collect, then you haven't cost them anything, so they shouldn't raise your premiums. I don't know if in practice maybe they do, I hope not. The problem is that insurance is a private contract. There's, unlike a rent increase where you go to the rental board, the landlord, the rental board says you can only increase so much. Insurance is a private contract. If they say to you, look, you're causing us, you're making a lot of claims, or even one claim, we're charging you $75 more per year next year, all you can do is shop around. You right. Can't, there's no rental board to take them to. So, if there's a damage in your apartment and it's the landlord's fault, you could try to claim from the landlord, and then you don't involve your insurance company, or claim from your insurance company. And if it's not your fault, they'll claim from the landlord and you should be okay.
And if it's the fault of another tenant in this particular case?
It's, in terms of insurance, it's similar. Okay, if it's the fault of another tenant, well, it starts to get more complicated. In general, it's going to be much easier to claim from your landlord because the landlord is responsible for providing you with the enjoyment of your apartment. So although there's many scenarios, let's take one. And a tenant causes a flood in your apartment, your upstairs tenant. You could, in theory, sue the tenant at the small claims court, but it makes a lot more sense to go to the rental board. I mean, well, to ask the landlord to do the repair, and for any damages, well, there's different things. Starts to get complicated. For
Right.
any damage, let's say, okay, there's two things here at least. One is the repair, and that it really makes sense to claim from the landlord and make sure the landlord does the repair, and if necessary, take them to the rental board. If there's a repair involved, it's just that there's so many scenarios. If the tenant simply causes a flood, just, lets their bathtub run with the stopper and there's no safety thing to stop the water from flowing, then it's the tenant who's purely responsible. So you have your choice there, claim from your insurance company and they will try to claim from the tenant. But if they don't succeed in getting that tenant to pay, you may have an increase in premium or sue the tenant at the small claims court. Those are the different options.
Okay, great. So we're a little bit behind. I'm going to wrap up the questions and let everyone take a bit of a break. Let Rick rest his voice and have a glass of water. So if everybody, I just want to see on the agenda how long we had put aside. Let's say we take 10 minutes. So we're going to come back and start at 15:15. So at 11:15, if everyone can come back on. Meanwhile, take a little moment to stretch your legs, have some water. And we'll be back for the second part. Thanks, everybody. Oh, and thank you to everyone who's putting links in the chat. That's super helpful. We're going to get going in a minute. So thank you for that. I have received more questions, but I'm going to save them for after this section, just because we are going to try and stay as close to on time as we can. So I'm going to turn this over to Rick again so we can start the second half of his presentation. Thank you.
Okay, thanks so much. And I see that somebody did very kindly find the article of the Civil Code 2925 about the 3-year prescription and put it in the chat, as well as an Éducaloi article on prescription, which I don't think cites the article number, but explains about prescription. So let's start this part on special issues regarding seniors residences. We can advance, please. Okay, so the rental housing laws affect private residences, not CHSLD, which are health and social services establishments, just like a hospital. But there are some specific rules and issues that come up. Well, they're subject to the normal rules, but there's some, you could say, I guess, additional issues that wouldn't come up in normal residential housing. And one was touched on earlier. Any services provided, such as meals, personal assistance, nursing, distribution of medication, cleaning services, etc., whatever they may be. There's a part of the lease, it's called Annex 6, that has to be filled out, that details the services along with their costs. So this wouldn't apply in a sort of regular apartment where the landlord is not providing anything like meals or personal assistance. So this has to be filled out. And when it comes to the rent increase, as we mentioned earlier, this is factored into the increase, just like the type of heating is factored into the increase. The cost of services is factored in, and there's a fixed amount that's allowed each year. I think it was something like 2% this past year that the landlord was. So if you're paying, let's say, $1,000 for all these extra services, meals and personal assistance, well, then hypothetically, there might be $20 extra if I'm right about the roughly 2% that was allowed this year. Okay, so let's advance. Okay, now this was a question that was put to me about what if you have to leave. There are different situations. One is if you have to leave permanently for a higher level of care. And so that we saw earlier when you have to leave, it's the same situation as a person's leaving a regular apartment for a senior's residence, or if they're no longer able to occupy their current apartment due to a disability, they can end the lease with a 2-month notice. Okay, yeah, let's stay on the slide. No. Okay, that's the one. So let's use the exact same example. You're living in an apartment where you already receive some care. You're already in a private seniors residence where you receive some care, but you now need a higher level of care, and you will not be able to continue occupying your apartment. It's not provided that level of care in that residence. You can end the lease with a 2-month notice. So for example, if you realized now, or you got the permission that you will be entering this residence with a higher level of care, rather than being responsible till the end of your lease, June 30th, you can send the notice now saying, well, the example I used before, you were admitted on February 1st to this new facility, that you will be leaving on February 1st and put an end to your lease. You have to provide a letter from a doctor or social worker explaining about the higher level of care that's required, and then you would be able to terminate your lease early. Okay, so let's continue. Okay, now this question was put to me. What if you're hospitalized, but you want to keep your room in the private seniors residence? You can do that, but you are responsible for paying the full amount of your lease during the time that you're hospitalized. So you don't want to give up your lease. You can say, keep it for me, but the landlord will say, okay, but pay your rent for that period, and you'll be able to move back in once you are released from hospital. Okay. So yes, let's advance. Sorry. Okay. Now it was put to me, what if a residence announces that it's closing? There are different options. You can ask the CIS or CUS to find you another residence. They are supposed to assist you with that. Or let's say you've found a whole other solution. You can terminate the lease with 15 days notice. So if you've got a better solution, whatever it may be, another residence that you found, or living with family, all depending on your personal situation, you can terminate your lease on 15 days notice in this situation where a residence has announced that it's closing. Okay, but we'll advance. Okay, now in addition to any issue that could be brought before the rental board, because like I said, it's subject to all the normal rental rules of all the normal legal rules of rental housing, there is a possibility of making a complaint. And to assist you with this, there's the Assistance and Complaints Program for tenants of private seniors residences, which you have the link. By the way, I have already sent this presentation to Ruth and Vanessa and Katja. So you are free to share this presentation with anyone who wants it, and therefore you don't have to worry about scribbling down the links or the organizations that will be mentioned. More will be mentioned later on. You don't have to worry about writing this down furiously. They can provide you with the presentation with the slides. Okay, so let's continue. Okay, I was asked about this situation, death of a tenant. So this is obviously not specific to private seniors residences, even though it may be often relevant to private seniors residences. But the rule is the estate can end the lease with a 2-month notice, similar to the other 2-month notices we saw for leaving due to a higher level of care or due to admission to a senior's residence in the first place. The estate can end the lease with 2 months notice. So let's say a person sadly has passed away now in the month of November. The estate would still, as long as they send a notice right away before the end of the month, the estate will be responsible for December and January, which probably is kind of the minimum time you need to organize things, clean out the apartment, and so on. But anyway, whether you need that time or not, the estate will be responsible for those 2 months till February 1st. So if they give a notice now, they can cut off the responsibility as of February 1st. The estate will not be responsible till June 30th. Now, if the estate doesn't have to give that 2 months notice right away, they can wait. They can wait till March. They can wait till April. Although if they don't give it within 6 months, then we're back to it's sort of like the estate becomes a tenant and we're back to the normal rules of lease renewal and so on. So if they don't use that right within 6 months, then we're just back to the normal situation. It's like the estate has become the tenant. So this applies for any type of lease. It applies in seniors residences, but it also applies in regular apartment. Many people do live out their life in a regular apartment and never live in a residence. So this rule will of the 2 month notice in the case of death of a tenant does apply. Now, if the lease, so now we're back to the seniors residence, included personal services, the types that we talked about before, personal care, meals, distribution of medication, nursing, etc., the estate is only responsible for the cost of services actually provided during the person's lifetime. So since no services will be provided, using the same example of a person who passes away in November, no services will be provided in December. No personal services will be provided in December and January, since the person sadly passed away. The estate will only be responsible for the rent, not the rent of the apartment, not the part that is for personal services. Okay, so let's advance. Okay, so CHSLD is not subject to rules regarding residential leases. There's a specific article of the code, of the civil code, that says a health and social services establishment is not subject to all these different rules about lease renewal and rent increase and right to stay in your apartment and automatic renewal and so on. It's not subject to those rules because it's a health and social services institution. Therefore, there's nothing in the rental law that says that they have to reserve the bed of a person who's been hospitalized. Now, I'm not an expert on the rules of health and social services institutions. They have to act reasonably. There may be reasonable policies in place that say, somebody goes for 3 days for an operation, I would assume they're allowed to keep their bed. But I won't be able to answer questions on that. There is the possibility of making a complaint where somebody feels that they have been treated in an unfair manner. This whole area of rights in health and social services establishment could probably be the subject of a whole other workshop, which I wouldn't be the appropriate resource person. But all this to say, because the question was asked, the way I understand the question, is there something in Quebec rental law that would, just like in a senior's residence, allow you to retain your place if you're hospitalized? And there's nothing in Quebec rental law that governs CHSLD. So it'll be some internal policy or policy of the Ministère of Santé et Services Sociaux that might protect your rights for a certain period of time to have your bed reserved if you are not occupying the bed temporarily, but it will not be Quebec rental law. Okay, so we can advance. So here, we're actually finished the content of the presentation. So we have some resources for you. Éducaloi, where we, if you go to our renting section, when you go to the law by topic on our website, you're going to see pretty much everything I've said, plus a lot more articles. The tribunal itself, which you can call for information, the complaints procedure for tenants of private residence. Then there are a couple of general legal information resources, community justice centers. You have a link for them there. They're places that you can call, sort of, they're information, legal information clinics. Normally they're walk-in, but I don't think they've reopened in-person service. It should be soon, I guess, because the government has announced now, starting November 15th, a gradual return to work in person. So you could check them out, and you can call them if you can't visit them. Let's go to the next slide, please. And so then there's different other resources, particularly some things for housing. Well, let's go back just a moment. This workshop has been oriented towards tenants, but landlords have rights too. And so there's a resource. Housing committees, they're around the city. There's one in pretty much every area of the city. Project Genesis, my former employer, brings back a lot of nice memories for me. They do a lot of housing information and very accessible by phone. McGill Legal Information Clinic, Mile End Legal Clinic. Should you actually be preparing for a hearing at the rental board, the Young Bar of Montreal has a service to help you prepare, because as I mentioned, most hearings are without lawyers. You do have the right for most hearings at the rental board to hire a lawyer, and some things such as some eviction cases are covered by legal aid if you're financially eligible. But if you have a hearing and you don't have a lawyer, they can help you to prepare. So that completes the content and the resources. So please go right ahead. Back to Vanessa, I guess, to moderate the questions.
That's great. Those resources are fantastic. I didn't know about some of those. So that's fantastic. I hope they were helpful. Yeah, we have a couple more questions. One is actually a follow-up from earlier. And it is, how long should you expect to wait to hear on a decision from the rental board on any kind of issue you're bringing to them?
It's typically a couple of weeks. There's that deadline is not set anywhere in the law, but it's typically a couple of weeks.
Okay, so it's not like these super crazy long deadlines.
Not like the Supreme Court where it hears a case and issues the decision 9 months later.
Yeah. There's a few discussions in the chat about pets. What are the laws? Are you allowed to have pets in your apartment? Do they have to be on the lease? There are questions about pet deposits. I don't think they're allowed in Quebec, but
a lot of good issues there. So I wasn't actually asked about pets, so I didn't include anything. It's sort of a tailor-made presentation, but we do have articles specifically on pets on our website, Éducaloi. You'll see that it'll be quite easy to find if anybody. I know someone actually nicely already posted an Éducaloi article if you'd like to while we're.
There's another article that's been posted too, but it's pets within Canada, and I think as usual the laws are slightly
No,
different.
we have on Éducaloi website. We have it. It's easy to find if nobody posts it while we're on the fly here. But I can answer the basics quite quickly. First of all, pets are allowed unless there's a clause in the lease forbidding them. So when you sign a lease, if you've got a pet or you think you might want a pet, check if there's a no pet clause. Another way to put it is a no pet clause. There we go. Pets in rental housing. I'm looking at the chat. Another way to look at it is this. The no pet clause is legal. The only situation would be is if somebody needs a service dog, for example. Otherwise, it is legal. There's nothing illegal about having a no pets clause that says absolutely no pets. So if you have a pet and you're shopping around for a new apartment, or you think you might be open to it, make sure that there's no pet clause in the lease. Otherwise, you won't be able to have a pet. Now, if you already have a pet, and there was never any no pet clause, it's not up to a landlord to just ban them. If they wanted to insert a new clause in the lease that says no pets, they have to follow a whole procedure, basically the same procedure as the rent increase. They have to send you a notice saying, well, they might mention their rent increase. That's fine. You know the rules about that. And they might say, and I also wish to modify your lease to insert a no pet clause. And you're not happy about this. You say, I refuse this modification, separate from you could accept or refuse the rent increase. That's fine. That's up to you. But on this no pet, you can specifically refuse that. It will then be up to the landlord to take the case to the rental board. And normally the rental board won't allow them to do this. There's no reason why a person who's been living there, the landlord's not saying there's a problem with your pet. They're just saying, I want a no pet clause. There's no reason why the rental board would allow the landlord to impose this clause on someone who's already been living there happily with their pet. Nothing will stop the landlord from, starting June or July 2022, from having a new policy that says every new tenant will have a no pet clause. That doesn't affect you. You've got your rights. Nothing could stop them from doing that. Then people decide, yes, no, they want to sign. But imposing it on a tenant where there is no problem with the pet, normally the rental board will say no.
Okay. There's an interesting question here about whether or not a tenant has recourse if a tree branch falls on their car. I'm assuming this happens on the property of itself, because if it happens on the street, I don't think.
Right.
But let's assume they're on the rental property and a tree branch falls and damages their car.
This wouldn't just apply to a tenant. I mean, if you happen to park in front of the building next door and a tree that is on that property, we're talking about not a city tree, but it's on that building's property, falls on your car, then that's a civil damages claim. It really has nothing to do with your lease. And the rental board won't hear the case. They'll say, look, it's not a rental matter. It's a civil responsibility matter. You could claim your damages from the landlord if you can send a registered letter, whether it be your landlord, the landlord down the street, or you're visiting your sister who lives in another part of the city, and you're parked in front of her building and the tree falls on your car. So it's not even in your neighborhood, you can claim it. So whatever it is, $5,000 to fix your car. The landlord doesn't pay, says, no, I'm not interested, I'm not paying you, or doesn't answer you. You can then, in this same 3-year period of civil liability, although there's no reason to wait 3 years, claim the damages from the landlord. Once again, take pictures, you've got your receipt and so on. And because it's less than 15,000, the example I gave is 5, I guess it could be more, but more than 15,000, because if it's less than 15,000, you're in luck, at least in terms of the legalities, because you can take the case to the small claims court where, like the rental board, it's done without lawyers. The procedure is simple. The cost is not nothing, but it's, I think, about $100 to take the case. And if you win, you even get that refunded. So it's a relatively accessible tribunal, whereas you start suing for 15,000, 50,000, whatever, the legal costs alone are going to be thousands of dollars.
Right. Okay. Someone has sent a message asking what a tenant's rights are with regards to cannabis if they don't want to be exposed to it, and I assume people around them are smoking.
We have a whole series of articles on that. So now I'm working more from memory. First of all, a landlord could have a no cannabis clause, and unlike the no pet clause, it was legal to insert it because this whole cannabis is a new thing. It only became legal about 2 years ago. So a lot of landlords inserted a no cannabis clause. And if somebody's violating that and you're disturbed, then it's up to the landlord to enforce this. And even, the tenant doesn't go along, evict the tenant. If there is no cannabis clause, then it's a normal disturbance. So if the tenant is not violating a clause of their lease, but they're disturbing you, then it would be similar to noise or any other, let's say the tenant is next door is filthy and your apartment gets a bad smell, then we're into you being disturbed, and you can take you can ask the landlord to end the disturbance. It's like a repair case, and to correct the situation. And if not, you can ask for rent decrease, damages, or even cancellation of your lease and damages to move, your cost to move elsewhere.
Okay. Okay.
So the first thing to check would be, has the landlord inserted a no cannabis clause? Because it puts you and the landlord in a stronger situation to take care of the problem, because then the tenant is violating their lease, and so therefore could be, it's much easier for the landlord to enforce this.
Right. Okay. I'm just going to ask you one more time, because there's a few questions on specific cases where people are bringing things to a landlord's attention and nothing's being done. So can you go over one more time? If someone is in their apartment, they've had a problem, it's not an urgent problem, but it's been an issue for 10 years. The tiles in the kitchen are coming up, or as you said, the window's leaking. What are the steps they need to take?
Okay, so after you've tried to do it in a friendly way and called the landlord, a formal notice, registered mail, 10 days, saying that if they do not rectify this problem, you will take the case to the rental board. I'm trying to think if I think we have a model. If we don't have a model specifically for landlord tenant on Éducaloi, just go to demand letters in Éducaloi and you'll get a rough outline that could be used for this, just like for any type of legal situation, just like the car situation where you say, you've got 10 days to pay me my $5,000 damages. So here you've got 10 days to do something about my tile floor that's lifting up. Otherwise, I will take the case to the rental board. Then hopefully they rectify it. But if they don't, you can take the case to the rental board, ask for different things, damages, reduction of rent, an order for the landlord to do the repair, and so on.
Great. Okay. Thank you. I think that covers a few. So I think, unless Rick, there's any last things you want to say or reiterate before we wrap up and ask people to do the survey?
Well, I'm just noticing myself in the chat. You've summarized them well, like the general situation. The specific thing of the son of the landlord, the son of a tenant, that wouldn't make a difference because the tenant is allowing their son to live there. They're just as responsible as if the tenant themselves was smoking.
I didn't even see this one.
Yeah, Anne-Marie and Suzette. My landlord sent me a letter saying I have to prove it beyond any doubt. That's ridiculous. I mean, it's just, they're watching too much American TV. In a civil case, it's not beyond any doubt. It's like you make your proof. It could be your own experience. You're testifying if it comes to the rental board. And it's a good idea to have a witness. So if nobody lives with you, have a friend, a brother, sister come over and smell the thing. And then they can serve as a witness and say, look, I was there on whatever date. It's really a very offensive odor. This is two people saying that it's an offensive odor versus a landlord who's not even in your apartment saying, I don't think it's a big deal. The rental board will normally have no choice but to believe the two people who were there and said, this is an offensive odor. This beyond a doubt is completely nonsense. So that's the way to do it for anything. Like you were saying, Vanessa, just common sense. And if it's something that's visual, take a picture. This is something different, a smell. I don't know if there's any way to measure. I'm not an expert of any kind. Maybe you can measure in some way the smoke in the room. If that exists, I mean, you can maybe make some inquiries. There are people who are building inspectors who are experts on measuring all kinds of things like radon, carbon monoxide. Maybe they can measure a smoking situation. Of course, you're going to have to pay them hundreds of dollars. It might or might not be worth it. But anyway, just to say this, beyond any doubt doesn't make any sense. It has no meaning in this context. So if you have witnesses, yourself and somebody else, you can, and unfortunately the landlord still doesn't act, you can take the case to the rental board, and the rental board has every reason to believe you and your witness.
Now, just to be clear, that if it's after 10 days and you haven't heard from the landlord, you can't go ahead and take action on your own unless it's an urgent case, right? Like you can't hire someone to redo your kitchen floor because you say the tiles have come up. You need to wait or go to the rental board.
Yes, in fact, it's not even, if it was urgent, you wouldn't even need to send the 10 days. Let's say, I mean, every situation is different. The tile floor could be an urgent situation. It's lifted up so much that it's literally difficult to use your kitchen. You could
Or
trip.
a fall risk for a senior,
Yes,
you know,
exactly.
yeah.
Yes. In that case, well, in that case, it could be urgent, and you wouldn't necessarily have to wait the 10 days. You could inform the landlord, call them up, tell them, or knock on the door of the janitor, tell them. The tricky thing is, of course, it's proving this. So it could be a good idea to go with a witness to knock on the janitor's door, or have a witness there when you call the landlord, put it on speaker so they hear that you reached the landlord. Because one of the issues with urgent repairs, okay, one issue is it really urgent? Like, I mean, how urgent is it? But another thing is whether you actually made a reasonable attempt to contact the landlord. And for that, because you're not sending a registered letter and giving them 10 days, it's a little more complicated. So one way is to have a friend come over, you put your phone on speaker, you call the landlord or the janitor answers, you tell them, my floor is so dangerous that I could easily trip on it. And by the way, if it's lifting up, is it because there's too much humidity? Is this the water accumulating? Like, what's going on? This seems urgent to me. And the thing is, every scenario is different. If it is because a pipe is, I don't know, is expanding or leaking, you probably don't want to be the one to be tearing up the floor and, paying a plumber and whoever repairs a floor, a carpenter, I don't know who, $10,000, and then trying to claim it from the landlord. It's a lot easier if the landlord actually does it themselves.
Yeah.
So, so those are the two kind of scenarios. It's urgent, you do it yourself after informing the landlord or doing your best, or it's not urgent, you inform the landlord, give them 10 days, and then take it to the rental board. There's no situation really where you would give 10 days and then do it yourself.
Okay. This is a good question. Do emails to your maintenance department have any validity in a hearing with the rental board? So it's not a registered letter, but you have an email saying, look, I informed them on this date.
An email is now considered as valid proof.
Okay.
If it didn't bounce back. It is more tricky though, because the person can say, look, I just never got it. The best is if they say, if you haven't acknowledged, let's put it this way. If you have an acknowledgement of some kind, like they answer you back and say, I received your email, I'll get to it as soon as I can, and they never do anything, that's perfect. If they never answer, it's just very tricky, because even though it didn't bounce back, so they got it, they could say, I just never got it. You don't have access to their computer to open it up and say, look, you got it on November 26th. You don't have that. So you're better off going back with the registered letter.
Yeah, I guess by default, that is the best way to go, especially if you're talking about big amounts of money, like new floors or new ceilings, or, I mean, those things can be expensive.
Now, another alternative that works just as well, but you need a certain amount of cooperation, is if there's a janitor or rental office, and you can go in with 2 copies of the notice, and they are willing to sign your copy as that they received it. That's just as good. Now, if there's reasonable civil people, why would they make you go to the post office and pay $14 when they can just sign it, and they know they're going to get it anyway? Why make you go to the trouble? So as long as they're willing to do that, just to summarize, you go in with 2 copies of the letter, whatever the letter is, about the floor, about the odor, whatever. You say, here's 2 copies. Can you please sign mine? received November 26, 2021, they say, sure, why, you know.
Yeah, that's good advice. Yeah.
That's perfectly fine. But if they say, we don't sign anything without the landlord's permission, well, then you're stuck.
Yeah. Somebody raised for email, there are those, no, I don't know, there are things like the read receipts. If you have Outlook, I don't know if Google does this, but if you send something and it says, you know, the sender wants to know that you've read this, and you click yes. I don't know if you have the option to click no, but it
I'm
shows
finding there's fewer programs that offer that. I don't know why.
people hate it.
I think it's because more people are using, I don't know if Gmail offers it. I know, for example, whatever we used to use with before Gmail that everybody,
Yeah,
like,
Outlook has.
or whatever it was called, my Thunderbird or something, you know, or Outlook. But everybody seems to be, or more and more are using web-based emails, which don't seem to offer it, or you don't get a clear acknowledgement of receipt. So it's like you say, Vanessa, it's pretty risky. I mean, if you're talking about maybe thousands of dollars of repairs, I wouldn't rely on that to prove that the landlord got it.
Yeah, make the annoying trip to the post office.
Mm-hmm.
Okay, well, I think that's it. Thank you to everybody, Rick in particular, the lovely Ruth Pelletier who found Rick or helped find Rick for us, and everyone for joining. We're going to send out a link to a little survey so we can get some feedback from you on how you enjoyed the process. Are we linking, Katya, or are we emailing? I'm not sure.
We're gonna email.
Oh, we're going to email. I think it ended up being easier. So we'll send this out to you. It will just take a few minutes of your time, not even. It's really quite quick. But the feedback is important to both us. We're going to share it with Rick so that he can also, you know, assess what worked in his presentation, or if there's things that you think need to be discussed further or explained more. That would be really valuable for us.
Will we get the slides, please?
Yes, we're going to send the slides out as well.
Thank you.
So thank you for joining, everybody. Thank you again to Rick Goldman.
Thank you, Rick. Thank
That
you.
was so valuable. Thank you.
My pleasure.
Excellent. Thank you.
Right,
You've been a
everybody, go
wonderful
enjoy the sun.
audience.
Thank you so much. Thank you for
Thank you.
putting it together. Thank you.
My pleasure.
And just to quickly clarify before people log off, the presentation will be included in the link to the recording of the webinar. So I'll send that out in maybe tomorrow or in a couple of days.
Thank you.
No worries.
Have a great afternoon, everyone.
Have a
Thanks,
good
everybody.
afternoon.
Thanks.
Thank you.
Thank you.
Bye.
Thank you.